Today is Monday, August 6, 2018, and my name is Stephen Fagin. I'm the curator here at the 6th Floor Museum at Dealey Plaza in Dallas, Texas. And the interview that we're doing today is part of our museum's ongoing oral history project. And today it's my great honor to be here with Howard Willens. Thank you so much for being here in Dallas to share your story with us today.
Well, thank you, Stephen, for the opportunity.
I want to start off by mentioning to the viewers of this that we also have, in addition to this recording, we have a telephone interview with you that we did earlier this year, and you were part of a videotape symposium at Southern Methodist University in Dallas about 5 years ago in 2013. So this is our third recording with you, but it's a very, very special and unique one because we're going to cover a lot of topics that maybe haven't been covered before. The way I like to start these oral histories, as you probably know by now, is to get you to just introduce yourself with your full name, date and place of birth, and just a little background about yourself to get started.
Yeah. Well, my name is Howard Willens, and I grew up in Oak Park, Illinois, which is a suburb just west of Chicago. I went to public schools in Oak Park and then went to college for a year at Stanford University, and then I transferred to the University of Michigan, where I graduated in 1953. I went then on to Yale Law School for 3 years and graduated in 1956. Following that, I had 2 years of military service with the U.S. Army, and I was stationed in Fort Lewis, Washington. Mm-hmm. Following that, I went to Washington, D.C., where I had hoped to practice law. I had chose Washington, D.C. rather than Chicago, where I had grown up, because I had a particular interest in public service and governmental issues, having been a poli-sci major in undergraduate years. And so I began practice with a small office of a Chicago firm by accident in the beginning of 1959. And through circumstances that we can explore later, I joined the Criminal Division under Robert Kennedy in 1961.
Well, this might be a good opportunity to ask you how you ended up going to the Justice Department when you did.
Well, I happened to be working in a firm with only 4 associates and 10 partners. I was the youngest of the 4 associates. I initially worked for a newly designated partner who specialized in antitrust law. He was a Yale Law School graduate, an extremely bright and ambitious lawyer who went on to achieve great prominence in the antitrust field. And he undoubtedly was instrumental in my being hired because I began working almost exclusively for him in my first year. In the second year, however, the firm got a very unusual assignment. Another younger partner, Herbert J. Miller, better known as Jack Miller, was a general practitioner in the office doing some litigation, some corporate counseling, and was generally quite known and well respected, having been a George Washington graduate and having many friends in the community. And Jack was asked to be the counsel to a 3-person board of monitors that was appointed by the U.S. District Court in Washington. It was appointed in order to implement the provisions of a consent decree that was entered into in a lawsuit initiated in 1957 by some Teamster dissidents who were trying to oppose the continued regimen of James Hoffa. Mm-hmm. The litigation went on for a few years until the parties were able, I think under some persuasion by the court, to reach agreement on a program that would tend to bring about changes in the operation of the Teamsters Union and a use of its finances and other issues that had been at stake in the litigation. The Board of Monitors, of course, needed a lawyer, and the person who was chairman of the board knew Jack Miller and asked him to assume this responsibility. So Jack went to the various associates, including me, and asked whether we would be interested in working with him on this challenging assignment of trying to implement reforms within the Teamsters Union. To me, it had somewhat more attraction than continuing my research on some of the antitrust laws that I was currently engaged in doing. So I enthusiastically signed up to work almost exclusively for Jack for the next year, as did at least one other of the associates, to the dismay of the other partners in the law firm, which was a very conservative law firm and somewhat apprehensive about taking on such a politically tinged legal assignment. In any event, it was an exhilarating year involving appearances in the Court of Appeals and continued concern about whether we were being trailed by representatives from the Hoffa side of the litigation to try to find out if we were doing anything inappropriate that might help his cause in the matter. In any event, the courts eventually got tired of this litigation, and but it was ended without any real firm conclusion. But in the course of that, Jack Miller got to be well known by Robert Kennedy, who was then counsel to a Senate committee investigating labor management issues, and even more importantly, his investigator, Walter Sheraton, a legendary investigator who in later years became an investigative journalist working for NBC. Walter was not a lawyer, but a superb colleague, and he too got to know Jack Miller. So when Robert Kennedy was designated to be Attorney General, he recognized that he needed help in staffing the various divisions within the department, and he did ask Brian Whizzer White of Colorado, a Yale Law School graduate who had been distinguished as a football player in his earlier years, to help staff the division. And as a result, many of the attorney generals were in fact Yale Law School graduates. But with respect to the criminal division, the new attorney general reached out himself and called Jack Miller and asked him to be the head of the criminal division. Jack reminded the new attorney general that he, Jack, was a card-carrying Republican. The new attorney general dismissed that as irrelevant, which was in fact quite unusual, because the criminal division is the division within the department that handles some of the most sensitive, politically oriented issues, and typically there has been a person there of the same political party as the Attorney General. Jack was quickly confirmed in February of 1961, and I began pestering him for a position in the division. Now, Stephen, it was of interest to me that I learned only within the last year or two that I was not Jack's first choice. In fact, he had asked one of the other associates who had been there a year or two longer than I had been, and with whom Jack shared family parties and social relationships to an extent that I personally had not had with Jack. In any event, the other associate declined to take Jack's offer out of concern that it would delay his progression to partnership in the law firm, and because he had 4 children and felt there was a financial risk in leaving private practice for an uncertain position in the department for an uncertain length of time, and with no guarantees that there would be a comparable place in a private law firm for him upon completion of his assignment to the department. So after that associate turned Jack down, he was somewhat apprehensive about my expressed interest in the position. I mean, I had no reluctance at all about pursuing the position, being perhaps naively and overly self-confident that I could handle whatever assignment I could find in the criminal division. In fact, when I looked at the organizational chart, I saw that Jack had 2 positions vacant in which I could be interested. One was as a special assistant to the Assistant Attorney General. The other was the position of second deputy to the Assistant Attorney General. Each Assistant Attorney General, by tradition in the department, had 2 deputies. One was typically a career lawyer within the department with many years of experience. The other was generally called a political appointee, namely someone that the Assistant Attorney General brought with him or her because of previous relationships and confidence that the person could do the duties. In this event, the second deputy position, which was third in the organizational chart, was open, and I indicated to Jack my interest in that position. He continued to insist that I think further about this because of the uncertainty involved in the task, because I was doing very well in the private firm, as he hastened to tell me. So he was trying to persuade me to either withdraw my application or at least think about it more seriously. I proceeded to obtain a set of documents which would constitute my application to the department if in fact he acquiesced in my request to join him. But he continued to delay until well into late April or early May of 1961. At one point I became impatient with this matter, and I took my completed set of documents applying for acceptance to the department and stormed into his office on the second floor of the Department of Justice, and I threw my documents on the table and I said, "Here are my documents, either take them on or let me leave." And he laughed, as he was accustomed to do. He accepted the documents, and I was soon after able to be cleared and joined the division in late May of 1961.
And how old were you at this point?
I was just achieving my 30th birthday.
Pretty young for a position like that.
Yes, it was very young, and I think to some extent there was some discontent or concern within the division that someone so young was being brought into that position. And I tried to deal with that in the early months as well as I could by spending time with the more experienced lawyers in the division, especially several of the section chiefs. And they were, for the most part, cordial, interested in my background, and enthusiastic about helping me learn how best to do the work that was called upon in Jack's immediate office.
From what you shared with me about your background, you seem to be a very capable and a very driven person, which are obviously traits that are going to come in quite handy when we start getting into the work of the Warren Commission. Let's go back to November 22nd, 1963. Everyone remembers where they were that day. What's your story?
Well, in fact, Jack Miller and I were out to lunch at a nearby hamburger joint, and we're walking back to the department fairly late, as I recall, when we were accosted by a fellow lawyer from the Criminal Division who ran up to us and said, "The president's been shot." And Jack and I could barely understand his words, but realized their implication, and we began to trot, if not run, back to the department, which was only a block or two away, at which point Jack quickly went up to the 5th floor, where he found the Attorney General's secretary in tears. In fact, the Attorney General was at his home in McLean, Virginia, entertaining U.S. Attorney Morgenthau from New York, who had come down to discuss various matters, including organized crime and other issues of common interest to them. So Jack, I'm sure, quickly linked up with the Deputy Attorney General, Nicholas Katzenbach, with Ed Gutman, the Public Information Officer, and remained there for several hours, whereas I and many other members of the division were back on the 2nd floor listening to a radio and perhaps television recording what was happening in Dallas. And that's how we learned, of course, within half an hour or so that the president was in fact deceased. And at that point, there was great uncertainty about what the Department of Justice should do on the matter. But in any event, that's how I learned about the assassination. And at that point, we began to collect ourselves to see what role, if any, the Department of Justice would have in investigating this matter.
As far as the rest of that weekend, Lee Harvey Oswald arrested here in Dallas, then he's shot on Sunday, and then the funeral on Monday. Are there any particular moments from that weekend that stand out to you today?
Well, I do remember, of course, seeing the assassination of Oswald on TV, as so many other millions did. I did return to the office on Saturday, actually, and found it almost thoroughly deserted. And I did encounter a Wall Street Journal reporter. In those days, and actually for the next decade or so, The Department of Justice was a government building into which anyone could enter without clearance of any kind. So it was no surprise that one of the few people I met was a young, driven Wall Street Journal reporter who subsequently achieved great prominence in the journalism field, who asked me, "Well, Howard," he said, "do you think things are going to be different at the Department of Justice now that President Kennedy has been assassinated?" And I looked at him with total dismay on my face, and because the question to me seemed so not only inappropriate but foolish, because, of course, the Department of Justice under Robert Kennedy had been a unique place to practice law, to serve public interest, because of the Attorney General's relationship to President Kennedy. I knew, as did everyone else in the department, that with the President now becoming President Johnson, that the Attorney General would not stay very much longer, and that it would be an entirely different department within which to practice the law. But otherwise, when I reported for duty on Monday, I was quickly engaged in conversations with Nicholas Katzenbach and Ed Guthman, the public information officer, who had a very talented assistant named Jack Rosenthal, who in his later career became one of the prominent journalists at the New York Times. In any event, we were aware that J. Edgar Hoover, at the direction of the president, had initiated a massive investigation of the assassination immediately after it happened on Friday. And of course, with the killing of Oswald by Ruby, the investigation was enlarged to reach Ruby as well. Whatever shortcomings J. Edgar Hoover had, the agency was capable of massive investigations in an organized and disciplined way. And the FBI did an immense job within the next 2 or 3 days. And J. Edgar Hoover personally provided daily reports to President Johnson as to what the findings were initially with respect to the assassination and also with respect to Ruby's entry into the basement of the police department and the killing of Oswald. It was quite clear to us and to Nicholas Katzenbach that J. Edgar Hoover was reporting directly to the president and was not sharing his findings with the Department of Justice leadership as he would customarily. In this case, however, Attorney General Kennedy immediately withdrew himself from any involvement in the investigation of the assassination of his brother. So reports designated for the Attorney General did not in fact go to the Attorney General. They went to the Deputy Attorney General and to Jack Miller as head of the Criminal Division. There were very limited reports that came from the FBI, and as a result, Nick Katzenbach asked Jack Miller to fly down to Dallas to see what was going on in Dallas and perhaps learn more about the nature of the FBI investigation by visiting Dallas than was available by staying in Washington and depending upon the FBI at the leadership level to share its findings. So Jack made a quick trip down by plane, I think probably on the Monday, and was immediately in telephone contact with the U.S. Attorney, which was Harold Barefoot Sanders, a former Texas lawyer in private practice who had been elected to the legislature and then appointed to be U.S. Attorney under the Kennedy administration. And the two men hit it off wonderfully, both being very collegial, good-spirited, with a commitment to the job, but also a willingness to share responsibilities and to consult about common issues. And what concerned Katzenbach and the department in general was that the district attorney in Dallas was, shall we say, releasing a good deal of information about the nature of the investigation, what was happening with the interrogation of Lee Harvey Oswald, and so forth and so on. And so one of the initial missions of Sanders and Miller was to persuade the district attorney not to be so voluble. and indiscreet in disclosing matters that might impair the successful prosecution of Oswald initially and subsequently of Ruby. They were only modestly successful in that matter and had to turn themselves immediately to a more important issue. Because of the death of Oswald, there was going to be no trial. Even if he had lived, it was more likely that he would be tried in Texas under Texas law rather than in the U.S. courts because, amazingly, we learned there was no federal law making the killing of the president under all circumstances a federal crime. So with the death of Oswald, however, there was not the traditional opportunity through a trial for the public to learn the facts about the assassination and to have explored in the traditional judicial context whether there was a conspiracy involved as well. So as a result, with the lack of that kind of traditional fact-finding venue, the federal government was confronted with the prospect of competing investigations. First, there was going to be a trial of Ruby, which undoubtedly was going to be thoroughly investigated and would proceed undoubtedly in an expeditious manner. More broadly, the Texas laws provided for a special court of inquiry that could be appointed to be headed by well-experienced lawyers or others to conduct an overall inquiry into the matter, which in this case would be both the killing of the president and the subsequent killing of Oswald by Ruby.
There was also a potential congressional inquiry as well, right?
That's exactly right. So there were eager members of Congress in both the Senate and the House scheduled to conduct investigations. So there were at least 4 competing kinds of investigations, and that became the impact of that gradually grew in Washington after Jack Miller and Barefoot Sanders drove together from Dallas to Austin because they understood that the Attorney General of the state was going to make an announcement in Austin about the Court of Inquiry. And so Jack tells the story a little bit about that trip together because both he and Barefoot were former smokers who had given up the odious habit. But as they drove under this tension, they both agreed that what they really needed was a pack of cigarettes. And so they made a stop. They each bought a pack, and they trundled along the road from Dallas to Austin, smoking heavily. In any event, at the meeting with the Attorney General, the question was presented to Jack Miller, well, would the United States conduct its own investigation if this Texas Court of Inquiry went forward? And Jack said affirmative, yes, indeed, it certainly would. So back in Washington, when Jack reported what he had learned, it began to be clear that the Department of Justice really was not going to be able to conduct its own investigation under those circumstances. And it was urged by Nick Katzenbach and others that President Johnson appoint a commission. He was initially reluctant to do so, first because his advisors, including J. Edgar Hoover, did not want him to, and secondly because he thought that this was basically a Texas matter and should be handled there. He was eventually persuaded, however, that having a Texas mechanism examine the assassination in Texas of a president that Dallas had voted against was not perhaps the most favorable or appropriate venue for such an investigation. So President Johnson was persuaded to appoint a commission and did so on November 29.
Well, the Warren Commission, this is something obviously that you became intimately involved with, but give me a sense of how things began, their earliest meetings.
Yes, I did learn in later years about the early meetings of the commission. Their transcripts became public at some time later on, and I looked at them, of course, in the context of writing my book about my experience on the commission staff. President Johnson, of course, was very savvy in his appointments and selected 4 members of Congress to be on the commission. Congressman Ford, who later became president, Hale Boggs from the Democratic side in the House of Representatives, then Senator Cooper from Kentucky, and then Senator Russell from Georgia. Senator Russell was very reluctant to join the commission. He expressed obvious distaste for the Chief Justice and the rulings that the Chief Justice's court had produced over the last several years. So he told President Johnson that he definitely would not work on the commission that was chaired by the Chief Justice. So President Johnson, as the telephone record relates, entered into a series of pleas to his former mentor to participate in this important national effort. He emphasized the need to have Senator Russell's experience, wisdom, and good judgment on board, and pled to appeal to his loyalties to the presidency. And finally, as Russell continued to deny any interest in service, President Johnson said, "I'm sorry, Senator Russell, I've already announced your appointment to the press." So Senator Russell entered the work of the commission with, shall we say, less than full enthusiasm, and in fact failed to attend most of the meetings of the commission. The two non-congressional members of the commission were Allen Dulles, who had left his position as head of the CIA in late 1961, in large part because of the debacle of the Bay of Pigs earlier that year. And the other non-congressional member was John McCloy, who had held a series of very important public assignments, including presidency of the World Bank, since World War II. So the commission had its first two meetings on December 5 and December 6, and they had not been given the official report from the FBI, which had been in large part already leaked to the public. They were uncertain about their role in those first early meetings, but as they became aware of what was developing, they decided that they really needed to conduct their own investigation. When they did get the copies from the FBI, they reviewed them, and the transcripts reflect a considerable uncertainty. I mean, several asked, for example, well, how did Governor Connolly get shot? Where did the bullet come from? And that's not answered here. And so they found, even in those initial reports, some important omissions or inconsistencies that troubled them. So whereas Mr. Hoover wanted his reports to be the end-all of the investigation, it really was only the very beginning of the most extensive investigation ever conducted in the United States. And so the members of the commission, once they realized that they had to conduct their own investigation of uncertain length and breadth, they needed staff. So they decided ultimately to retain Lee Rankin from Nebraska, but now practicing in New York. And Rankin had served in the Eisenhower Department of Justice for 8 years. His first assignment was as head of the Office of Legal Policy, which was responsible for producing legal analyses of executive actions and other important issues facing the department. And then his last 4 years were as Solicitor General of the United States. That is the position, as you know, that handles appearances before the Supreme Court, supervises the preparation of briefs for the Supreme Court, and Rankin in that capacity had appeared before the Supreme Court on numerous very important cases. He was well respected throughout the profession. Politically, he was a liberal Republican, but he was, as I learned subsequently, a great admirer of the Kennedy family. What's even more important, that many of his positions on behalf of the Department of Justice were accepted by the Chief Justice and embodied in the Chief Justice's decisions. In that respect, we knew that he had the high regard of the Chief Justice, which was incredibly important because the chief counsel of the commission really had to deal personally with the chairman of the commission on almost a daily basis. So the Deputy Attorney General, Nick Katzenbach, had attended the first 3 meetings of the commission only with their permission, because he made clear from the very beginning that the Department of Justice no longer had an official responsibility as a prosecuting mechanism, and the agency of the FBI was under J. Edgar Hoover, and the Katzenbach said that he was not in a position to speak for the FBI. So Nick Katzenbach, at the 3rd meeting on December 16th, when Lee Rankin appeared for the first time and joined the members of the commission in discussing these issues, it was decided that Rankin would begin to select members of his staff, and Nick Katzenbach suggested to Rankin and perhaps the Chief Justice that he might be able to find a warm body at the department who could be of assistance in helping the commission in these early days. So the next day, December 17th, I reported for duty and was called immediately into Jack Miller's office right across the lobby, so to speak, where we had 3 secretaries. And Jack told me that I had been volunteered by the Deputy Attorney General to go work with the Warren Commission. He asked if I was interested in doing this, and I said, I'm sure something sophisticated, like, of course, it sounds terrific. So I was enthusiastic to undertake the position. And I do not know really why I was chosen. I think it related in part to the fact that Katzenbach had dealt with me on various occasions throughout my, more than, 2.5 years with the department, and that within the last week or so, I'd been actively engaged with Jack Miller, with Nick Katzenbach, with Ed Guthman, and Jack Rosenthal, in dealing with the role of the department and what kind of role the department might have in the future. And now it was quite clear there wasn't going to be a fixed role for the department. And I'm sure that I was someone then who Nick thought of that he might suggest to help them out. So I think that to some extent I reasoned it, well, I was high enough in the department so that they knew who I was and that they thought I could do the job. And I was low enough so that the department could function just very well without me. So I thought and I was available. So I think it was a combination of factors and chance, and it's another one of those experiences that you relate to your children and grandchildren, that luck plays an important role in almost everyone's life. And I had a good deal of good luck in my career, and this was one of those early occasions where I was given an opportunity that almost every lawyer in the United States would have liked to have had.
And here at the outset, of course, you're not really sure what your role is going to be, whether you're going to be a liaison for the Justice Department or whether you're going to be more involved, and it turned out to be quite the latter because you were part of this supervisory staff.
Yes, there was a considerable uncertainty, which was prompted in part when I went to see the Chief Justice. My first meeting on December 17th was to visit with Rankin. And Rankin was, very, very courteous, very professional. He said he'd heard very good things about me from the Deputy Attorney General. He asked what my time commitment could be, and I said that, well, I had a couple of half days available, but that beginning in a few days I could work full time with him. And then he set up an appointment for me with the Chief Justice for the afternoon of the 17th. Now, as I recall, I had seen the Chief Justice recently within the last year because I had, by chance, argued a case before the Supreme Court. It was the first and only argument I had in the Supreme Court over the 60 years of my legal career. And it came about only because Jack Miller persistently argued to his colleagues that I should be given an opportunity of this kind during my assignment with the Department of Justice. I mean, he felt that in addition to the variety of bureaucratic tasks I had and my supervisory role at the Department of Justice, that I should have some exposure to the real world which included some cases in the courts of appeal and involvement in legal issues within the department. And of course, a chance to argue in the Supreme Court was, a benefit that I never expected to experience during my assignment. In retrospect, I probably should not have done that. I should have deferred to the traditional role that the other department lawyers play in dealing with the Supreme Court. But of course, once the opportunity was there, I set about to prepare myself, and I had the opportunity to work with B. Rosenberg, who was the head of the appellate section within the Criminal Division. And she herself was a very accomplished advocate before the Supreme Court and very well known to them. And she was especially valued for her ability to educate younger lawyers in the intricacies of writing effective briefs and in arguing cases. So she was very helpful in my preparation for the appearance. And it went off on the day as scheduled. And I received a few questions from the court. But it was not a difficult assignment substantively, because it was essentially a very simple case involving interpretation of the federal mail fraud statute. Under that statute, the use of the mail to create a fraudulent venture what was a violation. And if you used letters, or I guess telegraphs, to enlist investment, that was the case in this lawsuit, each of those letters or communications would be a separate count in an indictment, and the more counts you have in an indictment, the more likely the length of a prison sentence is going to be influenced. So in any event, the lower court had held that letters sent by the defendant after the fraudulent exercise had begun were no longer violations of the law if they were what we called lulling letters. In other words, after the 6 or 12 months, whatever the period was during which the investors were to receive their monies and profits from their investments, if nothing was done, they would make inquiries of the defendant and his associates as to when the investors were going to see their returns. And in response to those requests and pleas for information, the defendant and his colleagues would write letters placating the investors along the lines of saying, well, we're in the midst of an important project here, and we'll be done with that in the next few months and let you know promptly. Or we expect to have an important development soon, and you'll receive your monies next month. In any event, a series of these so-called lulling letters were the subject of a series of counts in the proposed indictment. And it were those counts that the district court rejected. And under the law at the time, the dismissal of a criminal indictment could be appealed directly to the Supreme Court. So that was the issue before the court. Were these so-called lulling letters indictable under the federal mail fraud statute? And the court held 8-1 with Justice Douglas in dissent in support of the government's position. So it was successful. If not my success, it was the department's success in vindicating the judgment of the prosecutors below to proceed along these lines. Of course, the Chief Justice didn't remember me. When I showed up at his chambers in the afternoon, he was as impressive close-up as he was across the podium, sitting behind the bench. And he spoke briefly to me about why he had taken on this assignment. Reluctantly, he admitted. But he went on to emphasize the international consequences of this event and the widespread rumors abroad and within the country, and the need for a reasoned and complete investigation. And he told me quite specifically that he did not want members from the government on the staff of the commission because he did not want anyone to be tainted by their allegiance to a particular government agency. And I said I was available to do whatever he and Rankin wanted me to do. And so we left on that terms, and I reported for duty thereafter. I did report the substance of that conversation to Lee Rankin. He did not have any response to the suggestion by the justice that I would be a liaison. And his answer eventually was not oral in nature, but in early January, based on 2 weeks of working together, he instructed his secretaries that everything that went out from the office of the Warren Commission should have a chronological copy marked for me. So it indicated quite clearly that he wanted me to be a part of the management of the operation, and within the next week or so, it became clear that he was asking Norman Redlich to take on special projects. The most important one was to prepare for the testimony of Lee Harvey Oswald's wife, Marina Oswald. And he expected me to review all the outgoing letters to investigative agencies about seeking further work by those agencies.
We need to mention Norman Redlich. We haven't talked about him yet.
Yes, and Norman Redlich was a professor at the NYU Law School, and he was a graduate with an exceptional record from Yale Law School in 1950, 5 years ahead of my term there. And he had worked in a family organization for several years, but apparently took an interest in tax law and got certified to teach tax law, but ended up being a constitutional lawyer at NYU. And he got to know Lee Rankin in early, after Rankin left the government in 1961. He opened up a law office in New York, and at some time following that point, he was asked by Norman to participate in a conference about constitutional law. And Rankin, having served so many years, including as the advocate before the Supreme Court, was a valuable contributor to that, and the two became friends. And so Rankin reached out promptly to enlist Norman on a variety of projects and to participate in the management of the operation.
So just to make it clear for those viewers who are approaching this new to the subject of the Warren Commission, really Rankin had the two of you, Redlich and yourself, as sort of his deputies, and the three of you formed this supervisory staff that oversaw all the other assistant counsel.
That is the way it turned out, although it was we didn't have any different titles, and these responsibilities were they were quite specific, and of course we quickly beginning in early January, began to meet regularly to discuss the important issues that were before us, involving personnel, organization, and relations with other agencies, all of which had to be immediately addressed. And Norman and I were joined for a brief period by one of the senior counsel suggested by Lee Rankin. His name was Frank Adams, and he was a former police commissioner in New York City. So he had extensive background in law enforcement and prosecution, but he was available for some days, perhaps a week, very early in early January. But then he had overriding responsibilities in litigating a major case that basically made him almost a non-participant in the further work of the commission, and that was unfortunate because he was a senior role in one of the important areas of investigation. But the other lawyers, I think, generally recognized that Rankin was in charge, and that Norman and I had different responsibilities. That they, for the most part, took it in good humor. But I'm sure that at dinners where neither of us were available for dinner, they would probably comment about so-called management and over-supervision, and questioned our suggestions on a variety of matters. But I think it all, there was a sense of camaraderie and understanding of the need for some effort to organize what proved to be a staff of 18 or 20 very independent, well-trained lawyers, each with a very firm sense of importance and ability to contribute to this national undertaking. So dealing with those people in a useful, effective, and friendly way was, of course, an ongoing challenge that I lived with for 9 months. And
you had a historian, Dr. Goldberg.
Yes, that was very interesting. It happened about in the middle of February when we had been operational for 6 or 7 weeks, really. The Chief Justice decided that he wanted to hire a historian, and it turns out that the Department of Defense has an army of historians. Each of the secretaries of the individual services had a historical operation. The Secretary of Defense had his own separate historian office. And Al Goldberg was the candidate that was selected from this group of historians to interview with the Chief Justice. And as Al Goldberg reports later to us, he asked the Chief Justice why did he want a historian on this commission staff. And the Chief Justice looked at him solemnly and said, "I don't trust all these lawyers." So Goldberg set out beginning to trust us. He often joked about being sort of an orphan as a historian among all these lawyers, but he undertook a variety of important assignments in very good humor, and he did a sterling effort along the way, and including some very unique contributions, and was a valuable contributor near the end in helping to edit various segments of the proposed report. But the one thing that Goldberg said at the initial meeting with the staff was he reminded them, which I guess was needed, that this was an important historical event on which we, including himself, were all engaged, and you might consider keeping some record or journal of what you're doing. And I took that seriously. I had never conducted written a journal or diary at any point in my life earlier, and I never did so at any point in my life later. But I decided in mid-February to write a journal regarding my participation in this event. And shortly after that meeting, I went back to my folders containing everything I had written and all the memoranda I had drafted and memos on meetings that had been conducted in which I had participated. And I wrote the first entry in the journal, which is about 5 pages, and deals with the early days of the commission into January, and focusing on personnel issues, organizational issues, bureaucratic issues, and so forth, trying to summarize in a way and capture the flavor of those initial weeks with the commission.
And the journal, which I've read thoroughly, it is a really unique contemporary window into the day-to-day operations of what you went through with the other staff members. And I think what we're going to do today for at least part of this interview is to go through your entries one by one and sort of talk about what you were thinking and feeling at the time, and how that affected the overall outcome and the writing of the final report.
Yes, no, I'd certainly be glad to do that, and I think with the usual qualifications, the journal entries were dictated quickly to my secretary, Adele Lippert, who had been with me at the Department of Justice and was incredibly capable and quickly became sort of a mother to all the other secretaries on the staff. Neither of us had time to reread the dictated entries. There were typographical errors or mistakes in speech by me, which I've tried to correct to some extent. The journal entries vary from daily entries about meetings and some endeavor to recall and summarize events going over a week or even 2 weeks. So, and my last entry was dated, I believe, August 21, and so there was yet another month of frenetic activity to complete the report, and certainly what happened there would have been in the journal, except at that point I was so busy I didn't have time for the journal.
We should point out that the book that was published in 2013, History Will Prove Us Right, you relied heavily on your journal for the creation of this book.
Yes, it was very, very important to me. The journal, the original version of the journal was in the attic for many decades, along with my 2 or 3 boxes full of commissioned materials. And there was reports of a mouse tampering with my journal, which was an offense to the national interest and personal interest as well. But when I turned to write the book, the journal was incredibly important, as were all the chronofiles that were created as a result of Rankin's instructions to his secretary produced a series of letters that were important, as well as other investigative reports and things that I had acquired or generated during the course of my work. The original of the journal in its tattered form is at the National Archives. I donated it and all of my papers to the National Archives in 2015, a year and a half or so after I wrote the book.
But for the purposes of this conversation, anyone watching this video, whether they're at the museum or elsewhere in the world, we are going to have a copy of the journal available so they can follow along as we go through entry by entry and discuss your thoughts.
All right.
If you're ready, I guess we'll go ahead and start with entry 1.